Cases number 66 and 67, Brown versus the State of New York. Brown is administratrix versus the State of New York.
Good afternoon, Your Honors. Jonathan Hitzus for the state. May I have 3 minutes for rebuttal?
Did you say 3?
3.
You may, sir.
Thank you, Your Honor.
You're welcome.
The Fourth Department erred here when it held that proximate cause may be measured only against a dangerous condition. Highway cases such as these indisputably proceed according to ordinary negligence principles, and under those principles, proximate cause is not measured against only a dangerous condition, but the breach of duty. And in negligence, the breach of duty is the failure to act as a reasonable person under similar circumstances. That's at the heart of all negligence cases. In the highway context, it's the reasonable person is a reasonable custodian of the roads. To measure whether or not the state's failure to act as a reasonable custodian of the roads would have had an effect on the accident, we necessarily need proof of what the state would have done had it acted reasonably.
Isn't that what happens when you get qualified immunity? And here, you didn't get qualified immunity because you didn't do the study and you didn't come up with you didn't do anything. And so could it be that the same standard applies whether you get qualified immunity or not?
Well, Your Honor, they're not the same standard. Qualified immunity applies if the state has completed a study. In that case, the state is immune regardless of negligence so long as the study was reasonable. Without immunity, the state, well, if the state
It's
doesn't...
like everybody else at that point.
Well, exactly, Your Honor, and the case
They have
proceeds...
a duty to keep their roadways in a reasonably safe condition, right?
That's correct, Your Honor.
Okay, so if it's not in a reasonably safe condition, and that failure to be in a reasonably safe condition results as a proximate cause of somebody's injury, isn't that the standard that we use for negligence?
Well, Your Honor, the failure to keep a road in a reasonably safe condition is broad. Like all negligence cases, how the state goes about
You're, to follow up on Judge Sain's point, focusing in on proximate cause. The PJI has had the same proximate cause analysis, which is that there has to be a substantial factor in connecting it to damages. And what we're talking about is duty breach. A duty exists, there's a breach of the duty. The breach of the duty was caused by a negligent act. We're assuming here that there was a negligent act. And then did that negligent act, can it be causally linked to damages? So here the question is design defect. Is it a substantial factor in causing this accident? You seem to be imposing two arguments, and you can address these. First, you seem to be saying that it has to be the only cause of the accident rather than a substantial factor. And secondly, you seem to be arguing that the petitioners or the plaintiffs here should be required to show that that there is no remedy to this solution, and therefore they're entitled to success on their argument, where the obligation to provide a remedy is not what the law requires. You seem to be creating a new requirement for proximate cause.
No, Your Honor.
Okay.
What we're saying is that the claimant here in a highway case, just like any other plaintiff in a negligence case, to show that the defendant here, the state, acted unreasonably necessarily implies that there has to be something that the state could have done that was reasonable.
Well, it could have completed the study.
Well, that's one of the things that the state could have done, and that was what the Court of Claims had measured.
It didn't do that, right?
Could have put a four-way stop in. There were 17 T-bone accidents from 1996 to 2002 at this particular location. The Ontario Town Board asked it to reduce the speed on Route 350 from 55 miles an hour to 45 miles an hour.
Well,
those are not onerous obligations on any government body. They're not asking them to rebuild the road. They're asking them to put in a four-way stop. After 17 T-bones, it's kind of, I think you're on notice. You've had the notice that your duty's been breached. It's hard for me to understand why you're not trying to impose an obligation on the plaintiff to show that there's an absence of remedy when the town board itself has asked for these remedies.
Well, Your Honor, your question presumes what we would be saying is the appropriate analysis here. Claimant didn't come in and simply say that the intersection was unsafe and leave the state to guess how it could have been safe. Claimant came in and said this intersection was unsafe and the state didn't act reasonably to the conditions at the intersection, because had the state acted reasonably, it would have put in a four-way stop sign. The failure at the trial stage was not about the standard, which is what we're arguing about here. It was about the proof. The problem with claimant's case is that even though claimant's expert initially opined that a reasonable custodian of the roads would have put a four-way stop sign in, claimant's expert then equivocated, admitted that a reasonable custodian of the roads would have taken incremental steps, and in fact proposed incremental steps in his
Let me
disclosure.
ask you a different kind of question. I want to know how you say we should understand the following statement by this court in Friedman v. State. When, however, as in Friedman and Muller, the cases involved in that appeal, analysis of a hazardous condition by the municipality results in the formulation of a remedial plan, an unjustifiable delay in implementing the plan constitutes a breach of the municipality's duty to the public, just as surely as if it had totally failed to study the known condition in the first instance. How are we to interpret that sentence in Friedman?
Your Honor, in all of these cases, irrespective of the statement in Friedman, I think it supports the notion that ordinary...
No, but I'm asking you about this statement.
This
Okay,
statement...
I don't want you to escape that statement.
It's a long statement, Your Honor, and as I
Well, I'm
understand...
particularly interested in this last section, a breach of the municipality's duty to the public, just as surely as if it had totally failed to study the known condition in the first instance. Isn't that saying, if you don't study the condition in the first instance, you have breached your duty?
Well, Your Honor, that would sound like the failure to study an intersection can itself be a form of negligence, which is something that I'll note the claimant alleged here, in which case the failure to study would be the breach, and you have to measure proximate cause against the breach, which is exactly what the Court of Claims did here. So that would tend to support our argument. The Court of Claims recognized that the breach of duty here was not the absence of a four-way stop sign, because claimant didn't establish that.
But this statement from Friedman, the state breaches its duty when the state is made aware of a dangerous highway condition and does not take action to remedy it.
Your Honor, reasonableness still remains at the center of this.
Is taking no action at all when you're on notice reasonable?
Only if reasonable care would leave the state duty-bound to take a particular action. The fact that the state does nothing is no different than any case of negligence by
But
omission.
isn't their argument really that it wasn't the state's fault, it was Friend's fault? He's the driver of the other car, right? Isn't that really the core of your argument?
No, Your Honor.
Okay.
That is our alternative argument. We want this court to find that the state couldn't be held liable as a matter of law here because claimant didn't prove proximate cause.
Let me ask you this. In Hain versus Jameson, you're aware of that, where the cow was in the road, or the calf was in the road?
Yes, Your Honor.
Right, okay. And there was negligence there, right? And did we say that the plaintiff had to prove what the farmer should have done to keep the calf secured? Did we say that she had to prove the specific thing that the farmer should have done to prevent the calf from getting in the road? Or did we just say that there was a duty to do something?
Well, Your Honor, we're talking about proximate cause here, and the duty to do something isn't enough. To know whether or not that something would have reduced the risk of an accident, we need to know what that something is.
Well, you'd agree that there's an overlap between breach and proximate cause, right? Because you have to show that there was something, right, that the defendant could have done.
Oh, absolutely, Your Honor.
And here, there was something that the defendant could have done, and that was shown.
Yes, Your Honor, but
Not necessarily that the defendant would have done that if it had done a study, but it seems to me that meets the plaintiff's.
Well, and this is an important distinction here. It's not simply a matter of would the state have done it. It's a matter of whether the state was duty-bound to do it. If we could measure proximate cause simply by a danger or the absence of safety...
But see, there is where, despite your response to Judge Fahey, you really are arguing that it's not a hazardous condition. That is really what this is boiling down to, that it's not a hazardous condition, so we really didn't have to do anything. It's the truck driver who's to blame in this because they could have seen the car.
No, that's not correct, Your Honor. In this scenario, we have a breach here, and we admit that there was a breach, and it was a failure to take incremental steps in response to the conditions at the intersection. We had both experts agree.
But why isn't
that
the four-way stop an incremental step?
the
And
four-way?
Her expert said that.
Well, Your Honor, the four-way stop sign has been conditioned by claimant's expert on the failure of those earlier steps, and claimant's expert couldn't determine with any kind of certainty when that four-way stop sign would be put in. As a result of that, claimant's expert wasn't able to carry claimant's burden to establish that the state had a duty to put in a four-way stop sign before the accident. In light of claimant's failure to carry that burden, the Court of Claims necessarily measured proximate cause based on the actual breach, which was the failure to take the earlier steps, which had been proposed as dual posting enhancements to the intersection warning signs on 350 and clearing foliage. Both experts agreed upon that, and all we're asking the court to do is agree that proximate cause has to be measured against the actual breach, not against something that the state wasn't found to have had a duty to do. Now, if I may, just very briefly, Your Honor, because we do have a secondary issue, the Fourth Department was alternatively mistaken if this court finds that the state can be held liable as a matter of law for finding that the state was 100% at fault. We understand that there are affirmed findings of fact here, but under those affirmed findings of fact, the only way that the Fourth Department could have found that the state was 100% at fault would be to infer that Mr. Friend, the other driver, was no better off than if he had entered this intersection blindfolded. The evidence not only fails to support that, it establishes the opposite. We have evidence here about the sight distance. We have evidence about the time that Mr. Friend waited after he looked south, and we have evidence about the speed of the motorcycle.
But if there was a speed limit change, if there was a four-way stop, then anything that would slow down, right, the meeting of these two vehicles very well could have avoided the accident completely. And Mr. Friend, I mean, you'd have to say that there's no evidence in the record to support the conclusion that Mr. Friend coming to that stop sign with the
vertical curve, Your Honor.
vertical curve, right, and the speed of the other car, that he could that it was impossible for him to see that other car or motorcycle, I should say, and motorcycle in time to have prevented that collision.
Well, precisely, Your Honor. If we combine the information we know about him looking to the south between 5 and 10 seconds beforehand, and we combine that with the sight distance.
The record is not really clear what the beforehand is before, right? Whether it's before the crash or before he enters the intersection.
Your Honor, on page 73 of the record, he's asked how long passed after you last looked south. He says less than 10 seconds. On a follow-up on, I think it's page 76, he says between 5 and 10 seconds.
Between what and what, though? Between when he entered and what?
Between when he entered and when he last looked south on Route 350. So in light of that information, we know that given the speed of this motorcycle, had he exercised reasonable care, he would have been at least able to see part of it. Now, maybe that lends itself to an inference that the motorcycle
the
was...
one-third of the vehicle is one-third of a car, presumably, and a motorcycle is a lot lower than a car, no?
Your Honor, there was nothing in the testimony to say that there were any kind of material deviations between that sight distance and what was at play here. And in fact, if we're talking about the averages that claimant's expert provided, those would have to be taken as a given for her own case because those were central to her showings about what the limitations were with the vertical curve.
Doesn't this sound like a fact argument to you?
No, Your Honor, because these facts are given. We don't dispute the facts. And under these facts, they would tend to show that this motorcycle would have been visible from 11 seconds out at 897 feet and fully visible at about 7 seconds out at 550 feet. We'd also note that the 5 to 10 seconds that Mr. Friend says that he last looked south should be construed as negligence per se. What it means is that he pulled up to the intersection, looked to the right, and counted to 10 or either to 5. and then he pulls in blindly. And where he has a duty to see what's there to be seen, this should itself be a form of negligence. In this alternative argument, we're not trying to vindicate the conditions at the intersection. We're simply trying to say that as a matter of law, the state shouldn't be held 100% at fault here.
Thank you, counsel.
Thank you.
Counsel?
Please, the court. Michael Steinberg for Ms. Brown. There are a few things I'd like to clear up at the beginning. Our argument has never been that the state was negligent in failing to conduct a study. We did say that they were negligent in failing to do something about a dangerous condition of which they had notice over property which they controlled. The state has said this is an abstract duty. I've even managed to get Paulsgraf into the case. But it's not an abstract duty. It's a concrete duty. It is a duty to take focused response to specific information about a given danger at one intersection. And the obligation of the state, once it finds that out.
Their argument is if they had moved in a way that your expert agrees they could incrementally, that at the point in time that the accident occurred, whatever they had done by that point would not have avoided that accident.
Yes, so their argument, and I'll get to the incremental measures.
What's your response to that?
First of all, Mr. Perrone was somewhat rattled on cross-examination, and on redirect, he said, yes, there should have been a four-way stop. I think it is accepted by everyone that the only thing, everyone who's passed on this case below, that a four-way stop was the only way of dealing with it. The incremental measures, Mr. Sherman says, wouldn't have done anything. What would be the point of double signage or flashing lights?
Is that the accident reconstruction specialist?
No, he was the state's expert, actually.
I see, okay.
That the problem with this was not that people on Patty Lane were unaware that there was a stop sign. You could make the stop sign as big as a billboard. It wouldn't make any difference.
He stopped, as a matter of fact.
He stops. And in fact, over and over and over again, people stopped there and didn't see somebody coming north. A fact which is completely inexplicable if we accept the
So
state's...
then doesn't that boil down to your position is the only thing they could have done is a four-way stop sign, which is exactly what he's saying. We've never said that you have to designate exactly from their side that they can take other steps.
With respect, Your Honor, we do not believe that we have to show what could have been done. We believe that the duty on the state is to make the highways reasonably safe.
But you have to show that something could have been done.
The state never argued that nothing could be done. They didn't make an impossibility argument. They said, well, we wouldn't have gotten around to it. We don't have to show what they would have gotten around to. We have to show that they have a danger on their property. They knew about the danger and they didn't do
But as I understood,
anything.
part of their argument was that the one thing that your expert said, this is the only way to resolve this, they were concerned that that might have resulted in other arguments on that north-south road.
I think at this point it gets into a technical question which takes away from the fact that there is a known danger here about which the state did nothing. I don't see any evidence in the record, sort of speculation that this might create a bigger problem. If we do get into the impossibility of, if they had gotten into the impossibility of resolving the question, making this roadway reasonably safe, the case might have taken a different turn. But the duty, it is accepted in our law that the highways can be made reasonably safe.
Let me ask you this, just turn into the alternative argument for a second. What's the effect of a friend's conviction on 1142A?
Friend's conviction after trial is, we submit, inadmissible. This court has, and he wasn't even a party. It's not admissible as res judicata against a litigant. I don't see how it can be introduced here. In any case, we have a perfectly good explanation.
Well, it's always that problem between court of claims negligence actions and Supreme Court negligence actions. But you can get if all the parties were together in Supreme Court, you would solve this problem.
Perhaps.
Yeah.
In any case, we have an explanation, which is the vertical curve, the sightline problem.
Well, that was Mr. Perrone's testimony. Is that correct?
It was accepted by the Court of Claims. It's an affirmed finding of fact that we have a
So are
vertical
you
curve
saying to me
problem.
that he took Peron's description of the vertical curve, the speed, over the police accident reconstruction specialist?
The police accident reconstructionist did not pay any attention to the vertical curve, and that creates a kind of ambiguity which the state makes use of in Judge Madej's decisions. Judge Madej says, yes, it's uncontested there are no obstructions. And this is true. An obstruction is something that is in front of you. There is, in fact, a sightline problem that is a kind of hidden defect that can only be found out by doing some surveying, which Mr. Peron did, and which the courts have affirmed existed there. And because of that, there's certainly, I mean, as far as Mr. Friend's negligence, it's a legal sufficiency question. And there is evidence from which a rational finder of fact could find that, indeed, he acted reasonably. He looked south at an appropriate time when he said, and it is testimony, is evidence, I said, I looked south and I did not see anything. He didn't see anything, and we know why he didn't see anything. We know why it's plausible, at least, that he didn't see anything, because of the vertical curve, and in fact, because of the accident history, where other people in Mr. Friend's situation acted the same way and had the same kind of disastrous consequences. Now, the state does bring in Weiss v. Fote, in a way, in, again, talking about what would have been done, what would have been the product of a study, and so on. And the thing is that since the state is not entitled to Weiss v. Fote immunity here, and since Weiss v. Fote doesn't set up any standard of reasonableness, it simply says we can't pass on the reasonableness of a duly arrived at decision of the executive branch. What the state is doing is really announcing a new law for dangerous conditions. In every case, in the case of the cow, it would be incumbent on the claimant or plaintiff to show not just what could be done, but when it would have been done. You know, when would that hole in the, you know, when would that quarry have been fenced off? Would it be reasonable to take other steps to put up a warning sign first? It would destroy centuries of premises liability law, because every plaintiff would have to come forward with a kind of speculative reconstruction of what a reasonable decision-making process would be. There's a reasonableness standard incorporated here. You have a reasonable time to make the roadways reasonably safe. How you go about doing that is not a reasonableness question, it's a technological question. And when the state has failed to make any steps at all in the face of a known danger, that in itself is unreasonable. That in itself is negligence. And the state says we are trying to have essentially liability without negligence. The Fourth Department erred, Mr. Hitsus writes, because it said we merely had to show that the danger was a proximate cause and not any negligence. But in fact, it is your negligent action in allowing a dangerous condition to persist that makes you liable for the consequences of that danger. And that, I think, is really where it is. The state knew about this. The state could have done something about it. The state did absolutely nothing. And they want us to say, well, if we had done something.
These are slippery concepts, but and I don't recall seeing it, so I'm asking you, and you can respond to it. Was there anything in the record about DOT standards on the number of accidents before an alteration or a change in the stop sign arrangement is required?
Nobody brought in the manual of uniform traffic control devices or anything like that.
Okay, thank you.
But, you know, basically the state's argument is, yes, we were negligent. We were negligent because we didn't conduct a study and we didn't do anything. But if we had not been negligent, if we had been reasonable, this intersection would be just as dangerous as it was before. And that can't be the law. The reasonable response to a known danger cannot be to do things which leave it dangerous.
Well, again, I think when he stands up, he can correct me. As I understand their argument, they can take incremental steps as they're determining what's the best way to respond. And I think their argument is that if it's a four-way stop you're looking for, that might not have been the step that they would have been at the time of the accident.
Well, we are getting speculative here for a certainty. That is why we think this is a bad argument. But let's assume that the state simply looks at it and trims some brush and so on. And let's even assume, I'll even grant, maybe the state did a study. And nobody sent a surveyor out there. Nobody found out about the vertical curve. Nobody understood why a particular kind of T-bone accident was so common there. We might be very well here arguing that, no, this isn't the kind of study that entitles the state to Weiss v. Foot liability because they overlooked one of the essential, obvious elements of the geometry of the intersection.
Thank you, counsel. Counsel?
Your Honors, our argument is not that the state can get away with leaving an intersection dangerous. It is simply that in this case, claimant proved breach, but not that the breach was the proximate cause. Claimant has an obligation to prove all of the elements of negligence, and one of these elements was missing. The state takes issue with claimant's argument that because these incremental steps wouldn't have resulted in a safer intersection for her, that the accident still would have occurred despite those incremental steps, that it means that the incremental steps were unreasonable. There are a host of steps that can be taken, and just because something can be imagined...
Might it not be a different case here if they did take incremental, if they did their study and they took incremental steps? Seems to me this would be a very different case, but that's totally theoretical.
That's theoretical at this stage, but I don't think it matters, actually, Your Honor. If the state had or had not taken incremental steps, what claimant's burden is still the same. Claimant has to come in...
What is the difference between meeting their burden in order to obtain immunity and this situation? How is their burden different, if at all? Are you saying it's the same?
No, Your Honor.
Whether they qualified for immunity because they did the study, they took it, they did whatever was reasonable under that study, versus if they do nothing at all?
No, Your Honor. We're simply...
What's different? I'm not understanding your argument.
If the state has immunity, then, or if the state can claim immunity, claimant can come in and say that that study was unresponsive to the exact condition here, or that that study was completely unreasonable. In a case where claimant proceeds in the ordinary course, however, claimant still has to come in and establish that the state acted unreasonably, not simply because it did nothing, but because a reasonable custodian of the roads would have taken a particular action, and then for proximate cause purposes...
I thought that's what their expert said.
That is what their expert said, Your Honor, and that goes to our point, that their expert understood what the burden is, claimant understood what the burden is.
Their expert said there should have been a four-way stop here.
That's correct, Your Honor.
Okay.
And they were unable to show that there was a duty to put a four-way stop in time to prevent this accident. The fact
Just to be clear, does the state concede that you should have done something? I get your
Yes.
point that you're saying you're not the proximate cause here of this accident, but does the state concede that you should have done something?
Yes, the state concedes a reasonable custodian of the roads would have taken incremental steps. And I'll note that the reason incremental steps are reasonable here is that DOT is
So you
not...
concede that a four-way stop would have been one of the things that you would have considered?
Only if prior...
Not that you would have put it in, that you would have considered.
Not at the outset, Your Honor. Not at the outset.
some point.
A four-way stop sign is an extreme remedy. That's something that bears itself out in the testimony. The fact that it might have conceivably prevented the accident doesn't mean you jump right to it. Closing down the road would have prevented the accident. It doesn't mean that the state's negligent for not closing down the road immediately.
No, but I guess the question you have to ask, and this is a more of a rhetorical question, so I'm not asking you to provide answers. How many accidents have to happen here before you do something?
Well,
Or you make either a change in the design the number of stop signs you put up there, put up lighting, put up strips, which they do now sometimes in dangerous areas. There's a variety of new techniques, but how many before something's done?
Well, and Your Honor, I understand your concern, and that's one of the reasons why the state is forced to admit here that it breached its duty, because it should have done something. And the question becomes, what is the nature of the breach by which you measure approximate
Does it
cause?
fall within that substantial factor category?
Well, the question for this court is what is the breach by which you measure approximate cause? Because the law is that approximate cause is measured by the breach. Our argument is that you can't simply say that a dangerous condition is the proximate cause, because that would erase the reasonable person from the analysis.
It could be more than one cause, right?
You certainly could have more than one proximate cause for an accident, and that goes
And that
to
could
our...
be that the state, at different points in time, has more than one, right? Their negligence at different points in time could be a proximate cause?
Sure, Your Honor, but that's something that would have to be proven by the evidence. Here, claimant had a fair shot to come in and say the state was negligent because it failed to put in a four-way stop sign. I'll also note just a quick correction. Whereas claimant says that the study was not alleged as negligence, you could find that on pages 281 to 82. I feel compelled to say that because we are absolutely not bringing Weiss v. Fode immunity into this. Without Weiss v. Fode immunity, this case simply proceeds in the ordinary course, and it is claimant who has the burden of proof to show that the state did not act as a reasonable custodian of the roads, and that its failure to act as a reasonable custodian translated to the failure to take the corrective measures that a reasonable custodian would have taken was the proximate cause of the accident.
Thank you, counsel.
Thank you.